let's talk about a law from 1882 that, believe it or not, is the invisible engine running behind almost every major thing you can own in India today. Seriously, whether you're buying a home, selling a piece of land, or even just gifting something valuable, the Transfer of Property Act is the rulebook. So let's dive right in. But first, let's go back in time. Imagine it's before 1882. You want to buy a piece of land. How would you do it? There was no single, clear law. How could you possibly prove you owned something? How could you be sure the person selling you that field actually had the right to sell it? The truth is, it was a total legal minefield. You had this confusing patchwork of local village customs mixed with English laws that, frankly, were not designed for India at all. The result? Widespread chaos and constant conflict. The system was completely broken. A clear, uniform law wasn't just a good idea, it was desperately needed. And that clarity finally arrived in the form of a new uniform law. This wasn't just about writing down some rules. It was about bringing order and security to one of the most fundamental parts of our lives, owning property. And you can see here, this was not an overnight fix. After decades of this messy, fragmented system, the first attempt at a unified code came about in 1870. But it still took another 12 years of drafting and redrafting before the Transfer of Property Act was finally enacted in 1882. At last, there was a single, standard rulebook for the whole country. So the Act is all about the transfer of property. But to really get a handle on the law, we first need to ask a basic question. What does the law even mean by property? The answer is probably a lot broader than you're thinking. You see, the Act uses a really wide definition. Property isn't just about physical stuff. Of course, it includes movable things like your books or your phone, and it includes immovable things like land or house. But it also covers intangible property, stuff you can't even touch, like a copyright to a song or the right to be a tenant. Now, here's where the law gets really clever. To define its most important category, that's immovable property, the Act starts by telling us what it isn't. It's a neat trick, right? Defining something by exclusion. And it draws a very, very clear line in the sand. In Section 3, the Act is super explicit. It says immovable property does not include three things: standing timber, growing crops, and grass. Now, that might sound simple enough, but it creates a really fascinating legal puzzle, especially when we start talking about trees. Which brings us to this surprisingly tricky question. If a tree is standing there, rooted in the ground, but the law says standing timber is not immovable property, then what on earth is it? The answer to this actually reveals a core principle of property law. And the answer, which was brilliantly clarified in the landmark case of Shantabai versus the state of Bombay, comes down to one simple thing: intention. What's the plan for the tree? If the idea is to let it keep growing, to get nourishment from the soil, say to harvest its fruit year after year, then it's considered immovable property. But if the intention is to cut it down soon for its wood, then legally it's treated as movable. It's all about the purpose. This whole distinction between movable and immovable is absolutely central to the Act. And it's not just some philosophical debate. It literally determines the entire legal process for how you buy, sell, or transfer something. The easiest way to think about it is like this. To transfer something movable, like a book, all you really have to do is physically hand it over. Simple. But you can't just pick up a plot of land and hand it to someone. Its transfer requires the formal, documented process of the law. This table really nails down the practical differences. I mean, movement is obvious. One can be transported, one can't. But look at the transfer. For movable stuff, just delivering it is usually enough. For immovable property, you need a registered document. That's why registration is mostly optional for goods, but it's compulsory for land or a building over a certain value. They're even governed by two completely different laws. Okay, so we've got a good grip on what property is. Now let's look at the action at the very heart of the Act, the transfer. What does it legally mean to actually convey ownership from one person to another? According to the Act, a transfer is specifically the act of conveying property from one living person to another, and that living part is key. It's why things like wills and inheritance are handled by different laws, because this Act is all about transfers between the living. And that transfer can happen right now, or it can be set to happen sometime in the future. The law also gives specific names to everyone involved. If you're selling your house, you are the transferor, and the person buying it, they're the transferee. It's simple, it's clear, and it's legally precise. Now, what's so crucial to understand is that a valid transfer is not just some casual agreement. It's a formal process with a strict checklist, and it's all designed to prevent fraud and create certainty. It has to be between living people, the property itself must be transferable, and the person doing the transferring must be legally competent, of sound mind and an adult. Of course, the whole deal has to be for a lawful reason. And finally, all the official paperwork, like registration and getting it witnessed, has to be done correctly. And this really brings us to the final and most critical point. The law gives us a clear roadmap. It tells us what can be transferred and exactly how to do it, but every single valid transfer, without exception, is built on one foundation: the legal capacity of the person making it. So knowing the rules is one thing, but being legally competent to act, that's everything.
Okay, so to make a transfer of, say, a house or a piece of land totally bulletproof, you've got to follow a very specific path. It all starts with getting the paperwork right, the attestation and documentation. Then, you have to get it officially registered. After that, the local records need to be updated through a process called mutation. And of course, the government gets its cut through stamp duty.
And get this, here's a wild little detail that's basically a time capsule from 1908. 100 rupees. Yep, you heard that right. Under the Registration Act, any property deal worth more than 100 rupees has to be registered. Now think about that for a second. In today's world, that tiny number from over a century ago means that pretty much every single property transaction, no matter how small, requires registration. It's an absolute must.
And once all the legal stuff is done, you're not quite finished. There's this step called mutation. Now, the best way to think of mutation is like updating the contact info in the government's address book. The legal ownership is already changed, but mutation makes sure the property tax bills and other official notices start going to the new owner. It's that final but super important piece of housekeeping.
All right, so we've moved past the paperwork. Now let's get into the principles behind the law, because it's not just about ticking boxes, it's about fairness. And that brings us to our first big idea, the doctrine of election. I like to call it the no cherry-picking rule. You take the whole deal, or you walk away.
And of course, the legal world has this awesome, very serious Latin phrase for this idea. It really sets the tone for just how fundamental this concept of fairness is.
Which, in plain English, means exactly what it says. You can't say yes to one part of a deal you like and then turn around and say no to another part of that same deal. The law says you've got to be consistent.
So here's where it gets real. Let's say someone gifts you this gorgeous old mansion. That's the benefit, obviously. But there's a catch. The gift comes with a burden. You have to maintain the historically protected and super expensive gardens. The doctrine of election says you can't just take the fancy house and let the gardens go to ruin. It's a package deal. You accept the benefit, you accept the burden.
And this isn't some brand new idea. It was hammered out in a famous English case called Cooper versus Cooper. The court basically said if you take the good stuff from a legal document, you're obligated to follow through on the entire document. And this exact same principle, it's baked right into Section 35 of India's Transfer of Property Act.
Okay, on to our second major doctrine. What happens when a property gets tangled up in a court case? Can the owner just sell it off to avoid trouble? Well, not so fast. This is where something called the Doctrine of Lease Pendens comes in, and it basically puts a legal freeze on the property.
Lease pendens, it's Latin for pending suit. And the idea is pretty simple. It stops someone from selling a property while it's being fought over in court, especially if that sale could mess things up for the other person in the lawsuit. It's all about preserving the court's authority, It ensures the final verdict isn't totally useless because someone sold the property out from under the case.
Now, this doctrine doesn't just apply to any old situation. A few things have to be true. There has to be an active lawsuit going on. It can't be some kind of scammy or collusive suit. And the property itself has to be a central issue in the case. If all those boxes are checked, then any transfer of that property is restricted.
But here's a really important twist, and it comes from a case called Harjeeb Singh versus Gurmail Singh. The law doesn't actually say a sale during a lawsuit is totally void or illegal. Nope. What it says is the new buyer is now stuck with the lawsuit. They are legally bound by whatever the court decides. So if the person who sold them the property ends up losing the case, well, so does the new buyer. Big risk.
All right, so we've talked about the official steps and some big protective rules. Now, let's break down the main ways property actually changes hands according to the Act. There are really 4 main paths.
And this table just lays it all out so clearly. You've got a sale, which is simple. You transfer ownership for a price, for money. Then there's a lease.
where you're not transferring ownership, just the right to use the property for a while in exchange for rent. An exchange is pretty straightforward. It's a property-for-property swap. And finally, a gift, which is when ownership is transferred freely with nothing expected in return. The key difference in all four is always the consideration, what is being given back, if anything.
Whew, okay. We have covered a ton of ground. So let's do a super quick recap of the fundamental rules of the property game we've just unpacked.
Okay, so let's lock this in. 1. Formalities like registration are non-negotiable. They make the transfer official. 2. The doctrine of election, remember? The no cherry-picking rule, you have to take the good with the bad. 3. The doctrine of lis pendens puts a legal freeze on a property in a lawsuit, so no one can mess with the court's process. And 4. Every transfer is basically a sale, lease, exchange, or gift.
So these rules are like the bedrock of property law, right? They're there to keep things fair and orderly. But, and there's always a but in law, can they ever be broken? Or maybe just bent a little? That's where things get really interesting. Thanks for diving into this with me today.